Hello everyone, my name is Shahad Haider. My group team member Usman Raza and Sana Khalid. Today we are going to give presentation on our course Business and Corporation Law. Uh, our lecturer name is Jonathan Temporal. So today our case study is on Essex versus Mariners Corporation Limited. The case is between the Australian Securities and Investment Commission and the plaintiffs, which is it is the plaintiff, and the defendant are Mariners Corporation and their three directors, which are Darren Olney Fraser. The second defendant is Donald James Christine and Matthew James Fletcher. So the judge, the jury of the judge is Beach J. The case was presented in the Federal Court of Australia Victoria District Registry. It was in Melbourne, June 2015. So the case is basically been divided into five categories. So we have divided into three different portions. So I'm going to give the introduction about the whole case, and the duties and responsibilities and the breaches that is been happened in the case. So we would like to give some brief introduction about the company. The company Mariners Corporation, which is listed in Australian Stock Exchange in the year 1986. So in the couple of years, they basically I would like to give some brief overview about the company. The company is basically dealing in investments in majorly in property, equipments and plants and different agriculture and office building related things. So most of their infrastructure being managed by a company named Global Rental and Leasing Private Limited. So the Australian Stock Investment Commission contended that the Mariners Corporation and their company's three directors have breached considerable rules and regulations of the Australian Corporation Act, and they have the most importantly what they highlighted that they have actually take over the shares of market shares or bid without the sufficient fundings of Austock Corporation Company, which is also a listed company in Australian Stock Exchange. So I'm going to discuss the breach of duties and responsibilities that is being done by the directors of the companies of Mariners Corporation. So basically the breaches that is being violated in under Australian Corporation Act 2001 is Section 180, which we are going to discuss. The overall, if we discuss with the overall case study, so there are two other violations being done, but it is related to the company's perspective, so we are not going to discuss that actually. So let me give you some brief introduction about the Act 180. This is regarding the care and due diligence conducted by the directors of a corporation. So basically there are two portions in that. A director's responsibility and exercise should be of reasonable care and due diligence before giving any decisions or any suggestions. They must take reasonable care, keeping in view of the interest of the company. Second thing is their decisions should be based on their business judgment, not on their personal and judgmental things. So I would like to explain the breaches and duties. So the first breach that is being done is been not taking good faith in view of the miners corporation interest, and it is they have actually offsetting the price of stock shares in the market. They have basically give false speculation in the market and taking over their shares with in less amount compared to the actual price which is being quoted in the market, that is 10.5. So however, while analyzing the whole scenario, when they start going to take over their shares, so it has been further realized that they don't have sufficient funds in order to even give fundings to the for the takeover of that. Now I would like to ask my group member Usman Raza to discuss further about the case.
Yeah, so now I will discuss analyze of the court decision and reason for decision in view of Corporation Act. The decision of federal court regarding the case of Mariner Corporation bears significant importance. The judgment rule of business recently was provided to really successful by the court as a defense that has been raised by three directors of the company. With court had provided really compelling insight in context of court that stated that director had relied on the responsible risk taking and not too much relying on advantages of the hindsight. In context to consideration and discussion, it would not be wrong to state that the decision of federal court seems to be really appropriate. If director would not take risks, then the company or firm would not be able to gain competitive advantages against the competitor. Similarly, on the other hand, it would be a real difficult to get hold of the high market share. Is analyzed of the Judge B.J. that responsibleness of the belief of director need to be assessed in context of the reference number of factors that includes number 1, significance of business judgment made, number 2, time available of obtaining the information, and number 3, cost in content of obtaining information, and number 4, officer or director confidence in exploring the matter, and number 5, state of company and business and nature of the competing demand on attention of the board, and the last one, where the material information has been reasonable available to director. It is considered that after viewing the set of perspective and components, decision of the tribunal seems to be appropriate. However, after considering the discussed six factors, it seemed that the director were able to fulfill their duties and responsibilities. And now I would like to ask my group member Sana to elaborate further.
Now moving towards the next point, I'm gonna elaborate the next point, which is relevance of the decision to the development of Australian corporation law. In this point, Corporation Act of 2001 Section 80 clearly identifies and specifies the set of the duties that are considered and deliberated to be fulfilled by the directors. It is considered that if the duties are not fulfilled by the directors with their complete care and diligence, lot of the issues and problems can be raised in text to the weak corporate governance. The case of Mariner Corporation Limited is really interesting, as it not only has reflected the significance of taking the right decisions, but has also reflected and indicated that if the decisions are not taken in context to the viewing of the real situation, a lot of the further issue can be faced. In according to my understanding and learning, the decision. Now moving towards the next point, which is relevance of the decision to the development of Australian corporation law. In this point, I will discuss about Corporation Act of 2001, Section 80, clearly identified and specifics the set of the duties that are considered and deliberated to be fulfilled by the directors. It is considered that if the duties are not fulfilled by the directors with their complete care and diligence, lot of the issues and problems can be raised in context to the weak corporate governance. The case of Mariner Corporation Limited is really interesting as it is not only has reflected the significance of taking the right decision, but has also reflected and indicated that if the decisions are not taken in context to the wing of the real situation, lot of further issue can be faced. In accordance to my understanding and learning, the decision taken by the federal court might very positively lead to the effective development of the Australian corporation law, as it would do provide the director's significance of taking the decision on the right domains and considering all the possible perspective and aspects. Now I would like to give conclusion on this case. In accordance to the analysis and discussions, it has been concluded that Mariner case overall illustrate that rule could offer really successful defense in context to the decision and concern significant transactions. It is considered that Mariner case might prompt some of the further exploration as well as can deliberate the utilization of defense in other matters. In simple terms, it is deliberated and examined that the director should be very aware of all the entire elements of rule of business judgment, section 180. Directors should be only working and making decisions for the benefit of the company, rather than considering their own material personal interest. Moreover, on the other hand, it is very important to note the Mariner case illustrates on directors in informing themselves about subject matter of judgment. Basically, business judgment rule is not considered itself as defense to the contravention of related other duties and include misuse of the passion, solvency, obligation, and misuse of information.
So now I would like to thank all of my group members who gave their utter determination and effort for the completion of this assignment and plus the video presentation. And lastly and most importantly, I would like to thank to our lecturer who gave us the opportunity for considering our presentation on the case. Thank you very much.
Thank you so
Thank
much.
you.
Thank you.
Thank you.